In our last lesson, we talked about independent civil actions. An independent civil action is a civil action that arises from any other source of obligation except from a crime or felony. They may be filed at any time even when there is a pending criminal prosecution. Independent civil actions exist on a parallel reality with the criminal prosecution. The acquittal or conviction of the accused in the criminal action has no bearing, no impact on the outcome of the independent civil action. However, there are two important rules that bind them. First, the quantum of evidence required in independent civil actions is mere preponderance of evidence. Second, the injured party cannot in any way, shape, or form recover twice the damages. He or she cannot recover damages in the criminal case and at the same time from the independent civil action. Tonight, we're taking a look at another class of independent civil actions, and this one is the one under Article 34 of the Civil Code. By the end of tonight's lesson, you should be able to 1. Identify the rules that bind independent civil actions. 2. State the requisites for the applicability of Article 34 of the Civil Code. 3. Explain the basis behind the independent civil action against city or municipal police officers. All of this and more coming right up. This episode is brought to you by Dekada! 10 life lessons from 10 years in law school. Sa akdang ito, ako na ang nagkamali na dapa, lumuha at nasaktan para ikaw kapatid ay makatapos sa loob ng 4 o 6 na taon. Think of it as a game guide, a cheat sheet that you can use throughout your law school journey. By purchasing this ebook, you are sowing the seeds of free legal aid for those who fall within the gaps of the law. With your help, we can bring the law to the people and more people to the law. Grab your copy through the link in the description down below. Hi, my name is Lex and welcome to Lex in Motion. In this channel, I'll be helping you build your competence, confidence, and capability in law school. Start today by hitting the subscribe button below. New episodes are posted every Friday. Article 34 of the Civil Code provides that when a member of the city or municipal police force refuses or fails to render aid or protection to any person in case of danger to life or property, such peace officer shall be primarily liable for damages, and the city or municipality shall be subsidiarily responsible. Therefore, the civil action herein recognized shall be independent of any criminal proceedings, and a preponderance of evidence shall suffice to support such action. Article 34 of the Civil Code defines for us another independent civil action. Sa ilalim ng provision na ito, ang ating kapulisan ay may obligasyon na tumulong sa sino mang humihingi ng saklolo o ng tulong. Kung mayroong pagbabanta sa kaligtasan ng isang tao o ng kanyang ari-arian, trabaho ng ating kapulisan na tumulong sa kanila. Ang miyembro ng kapulisan na hindi tumulong ay magkakaroon ng pananagutan sa ilalim ng ating batas. Ang pananagutan namang ito, kapatid, ay isang independent civil action. Meaning kung ang ating kapulisan ay mahahabla sa ilalim ng ibang kaso maliban sa salang kriminal, ang kaso sa ilalim ng Article 34 ay maaaring litisin at walang impact ang naunang kaso sa magiging ending o kahihinatnan ng ating independent civil action. Ang pagtalikod sa tungkulin ng tumulong o magbigay ng saklolo ay papatunayan lamang sa pinakamababang quantum of proof o quantum of evidence, at ito ay mere preponderance of evidence. For Article 34 of the Civil Code to apply, the following requisites must be present. 1. A person or his or her property is in need of help, aid, or protection. 2. A police officer refuses or fails to render help, aid, or protection. 3. The police officer becomes primarily liable and the city or municipality becomes subsidiarily liable. 4. The action to enforce such liability is bound by the rules of independent civil actions. Kung ikaw, kapatid, ay nagmamadali dahil gahol ka na sa oras sa klase o sa review, ay maaari ka nang mag-skip sa susunod na lesson. Dahil ang Article 34 ay isa sa mga topics na tinuturing na reading matters pagdating sa persons. Kung itatanong man ito, bilang bahagi ng enumeration ng independent civil actions. This is something we have discussed in previous lessons. If you are still here and you want to learn more, let me start off by contextualizing this provision. At present, the Philippine National Police is attached to the National Police Commission, which in turn is attached to the Department of Interior and Local Government. Article 34 here refers to city and municipal peace officers. And this is an anachronism. There was a time, kapatid, where the local government units had direct control and supervision over the police force. There was a time when some corrupt mayors used police officers as their personal bodyguards or as their own private armies. Now, all of that has changed. The National Police Commission or NAPOLCOM exercises the direct control and supervision over their units with close coordination with the local government units. Thus, this means that Article 34 of the Civil Code is no longer applicable. There are no Supreme Court cases as of the time of this episode on Article 34. Hindi naman din ibig sabihin na wala itong kabuluhan, kapatid. Police officers wherever they may be found still have the duty to render aid or protection to any person in case of danger to life or property. Police officers have been specifically called upon to help us during this pandemic. They man checkpoints and enforce quarantine protocols in close coordination with local government units. In my hometown, I still see some of them helping elderly ladies or pregnant women cross streets. Dean Albano makes a wonderful point on this. Our police officers are an external symbol of our government's power and authority. This is why an attack or an assault of a police officer is specifically defined by the revised penal code as a distinct and separate crime from, say, assaulting or causing physical injuries upon another person. Because police officers are treated differently, they are also specifically enjoined by the law to provide help and protection for any person whose life or property is in danger. I hope that's clear, kapatid. Second, let's talk about liabilities. In our laws, there are three forms of liability. These are primary, subsidiary, and vicarious liability. All of these you will encounter again in torts and damages, but allow me a few minutes to discuss all three dahil sabi nga nila, lamang ang may alam. Primary liability exists between the person who causes an injury and the injured party. Walang mahirap unawain dito, kapatid. Kung ikaw ay nagmamaneho ng sasakyan, medyo mabilis ka na rin dahil late ka na. At sa iyong pagmamadali ay may nabangga ka, pananagutan mo siya. Subsidiary liability, on the other hand, is the liability that exists between someone who exercises direct control and supervision over the person who actually causes the injury and the injured party. They are made to answer upon the default of the person who causes the injury. Karaniwan nating makikita ang subsidiary liability sa mga employer o amo ng mga taong nakaka-aksidente o nakakaperwisyo ng iba dahil sa kanilang kapabayaan. Here, the person who is made liable under the law really had nothing to do with the injury. They are merely liable because the person who causes the injury cannot pay for the damages. Kung kinasuhan ng reckless imprudence resulting to damage to property ang isang taxi driver, siya ay ang person primarily liable. Kung hindi siya makabayad, kailangan siyang saluhin ng kanyang employer o ng kanyang taxi operator. There are obvious exceptions to subsidiary liability. One of them is when the employer is made primarily liable based on contract. Karaniwan itong nakikita sa mga service agreements between security guards or janitors in relation to their agencies. The security agency becomes primarily and directly liable to the client, so long as their contract so provides. Shoot na yan, kapatid. At bahala na ang agency na humabol sa tao nila. Another exception is when the employer is able to demonstrate that he or she exercised the diligence of a good father of a family in the selection and supervision of their employees. When this happens, the liability is passed back to the tortfeasor or back to the person who caused the injury in the first place. Again, this is something we will discuss more when we get to torts. For now, let's look at the third form of liability, and that is vicarious liability. Vicarious liability is the liability of a third person upon the actions of another. In vicarious liability, the person made liable has nothing to do with the injury, but because of their unique relationship with the person who caused the injury, they become directly and primarily liable to the injured party. This is the essence of vicarious liability. Ang classic na halimbawa ng vicarious liability ay sa mga parents and their minor children living with them. Let's discuss the very short case of Tamargo versus Court of Appeals. Macario Tamargo, Celso Tamargo, and Aurelia Tamargo filed an action for damages against Adelberto Bundok, who was 10 years old at the time, for shooting Jennifer Tamargo with an air rifle, which caused her death. Before the shooting incident, Victor and Clara Bundok had given up their son for adoption to the spouses Sabas and Felisa Rapisura. The petition for adoption was still pending at the time of the incident, and Adelberto was then living with his natural parents. The Supreme Court, speaking through Justice Feliciano, teaches us that Article 2180 of the Civil Code provides that the obligation imposed by Article 2176 is demandable not only for one's own acts or omissions, but also for those of persons for whom one is responsible. The father, and in case of his death or incapacity, the mother, are responsible for the damages caused by the minor children who live in their company. This principle of parental liability is a species of what is frequently designated as vicarious liability, or the doctrine of imputed negligence under Anglo-American tort law, where a person is not only liable for torts committed by himself, but also for torts committed by others with whom he has a certain relationship and for whom he is responsible. In the instant case, the shooting of Jennifer by Adelberto with an air rifle occurred when parental authority was still lodged in respondent Bundok's spouses, the natural parents of the minor Adelberto. It would thus follow that the natural parents, who then had actual custody of the minor Adelberto, are the indispensable parties to the suit for damages. Sige kapatid, I promised a very short lesson tonight, so I will deliver on that promise. To summarize tonight's lesson, number 1, Article 34 imposes an independent civil action upon police officers who fail or refuse to render aid or protection to anyone whose life or property are in danger. 2, the police officer is primarily liable and the city or municipality becomes subsidiarily liable. 3, there are 3 kinds of liability: primary, subsidiary, and vicarious. Primary is imposed directly upon the person who causes the injury. Subsidiary liability is imposed when the person primarily liable cannot pay. Vicarious liability is imposed based on the relationship. It is also called the doctrine of imputed negligence. I hope you find the time to read the case all on your own. There is a short quiz to test how much of this lesson you have understood. Please post your scores kapatid, dahil mas ganado akong gumawa ng lesson kapag nakikita ko na meron kang natututunan. If you would like to see more lessons on persons, please let me know by typing yes in the comments down below. Thank you so much for watching. Like and share this video for good law school karma, and I will see you next Friday.